So the cartoon she's watching now is Word Party. And she loves, as y'all know, she loves Tad the Explorer. So I'm trying to figure out other cartoons that she would probably like. So she loves Shrek.
The ones that I can think of, this is a long time.
What's one? Oh, I remember Octonauts.
And then what about that one on Disney where they're the explorers?
Oh, which one is that?
What about Little Einstein?
Little Einstein.
Ah, okay. I'm gonna let them know about that.
Yeah, that one's a good one.
Okay.
That's the only thing.
Well, I don't know, Wildcats is like more of a learning one. That's like for little older kids, right? Like 5 or 6.
All right. So
I think anything like young Disney, like for
Wildcats is a good one.
what?
Wildcats, CRAT. But they're like older, so I mean,
I'm like crazy about like what they always do as far as, like Pokemon and all that stuff.
Hi. Okay, my niece loves Coco
Oh,
Melon.
does she?
Yes.
I just didn't know, you know, if it's more than anything else. That's my kids who are small.
All right, guys. It is Friday. We're going to start back up with our jury trial at 9:30. So everyone's going to need to move with the purpose. In custody, I have Jose Cano, Mario Aguilar, and then we're going to have Eduardo Escalera, Sherry Cooper, and Richard Thomas is going to be at 9:30. So everyone, please confer and please move with the purpose. But it's Friday, so it's going to be a great day.
Yes. Is the tacos that I brought?
Oh, yeah, those tacos are very good.
Yes, thank you.
Made me go all the way to that place. Man, I got lost.
Thank you so much.
It's just right there.
They asked me, are you feeding a tribe or something? I said, it's a whole bunch of cops and a hungry judge, you know, I better give me some. I'm walking, what you saw me, and the cops at the first like, is that for us? And then like, they grabbed it, I was like, yeah, to fight with the 187. Oh, we'll go over there. I'm like, no, it's like piranhas.
All right, so I received a letter that has brightened my day. It is from Lamont Ward. He said, because of something I've done, that he is actually enrolled in law school. I know he's going to do fabulous. He's going to have to, and he's going to be at Texas A&M School of Law. So everybody at Texas A&M School of Law better be welcoming to him. Otherwise, I'm going to drive to Texas A&M. But that is so fabulous. Congratulations, Lamont. You're going to do fabulous in law school. And you know what I always tell people about law school? Everybody's always worried, but after the first year, it's all downhill. I mean, well, not downhill in a bad way, but after you, I always say it's all downhill. But after the first year, you will say, what the heck was I worried about when you get to your second year? So after the first year, it's fabulous. But I'm so excited for him.
Let's step up to the plate.
Oh, you're stepping up to the plate?
Good to see you, Judge.
Good to see you too. I saw you on the bench outside.
And that's the only bench I'm running for.
Oh, okay.
I know to stay away from such things. So I'm going back to the civil side. Wait a minute. See, Judge, when I used to try criminal, that one, I did a plea. Steve. Oh my goodness, who's the one behind you? Not a clue. I'm too far removed, Judge.
See, and you know what? I think the reason why I had a portrait unveiling, I think everybody should know, all the judges who are in court. I'm trying to do a portrait unveiling for everybody's court. And there are actually, we had got a list of judges, and of course, each judge is in charge of their own court. And I don't know if some judges are like, I don't want to do that. But we were coming up with a list, and then we talked to Judge Carruthers because we thought we had our list all together. He's like, well, there's this person, this person. I'm like, who is a Judge Bell? I never heard of Judge Bell. He was going through so many
Oh,
people.
Andrew, yeah, we all go, I would, his wife, her and I, Willie,
Yes.
oh yeah, I've been doing this a little while. I know I don't look it.
You do not look it.
Thank you, I appreciate that.
Hey, it's the truth. If it wasn't the truth, I would just say, oh, you know.
Well, Judge, thank you so much. I'll talk to you later.
All right, good seeing you. All right, can I see the officer on this? If you come around this way, please. Could you raise your hand? Is all true directly with your personal knowledge? Oh. Are you? Where's the cowboy hat? Where are the boots? Where are the jeans?
Hoping nobody would call me out.
Well, I mean, I always wondered, I'm like, is that what they wear? But they're missing. Okay. You know, I always try to do research because I always want information. And so I'm always wondering where did that outfit come from?
It's just,
So do you get that as a tax write-off to get that, or?
no, unfortunately, it's like every ranger back in the day had to pay for all their supplies and all that stuff. Okay, so the illegal predated his. So how I probated all that.
There you go. You're welcome. Have a great day. Oh, I think they took it. Hi, are you ready? So which case are you all on? Jose Cano. Are you all ready to proceed with the actual MTR?
Yeah, Judge, we got.
I believe we've come to an agreement on this. council was speaking to my partner, Ms. Brittany Mitchell.
Mhm.
Our proposed agreement would be to continue the defendant on probation for 6 months, but altering and amending conditions for GPS to be able to track the defendant. And
All right, let's go on the record. Diana, are you ready?
Yes, ma'am.
All right, the court is calling 2022 CR 3600.
Sorry, Judge.
Oh, no.
My mistake.
Okay.
We need an interpreter.
All
I'm
right.
So sorry.
No problem. Could we have an interpreter call down, please? So we'll make sure we take you up. No problem. We're going to get an interpreter. Okay, so parties on this case, Keno?
yes.
All right, so on this case, he re-entered.
Correct, Your Honor. He's charged with this. From the supplemental report, it does indicate that the illegal entry actually predated the granting of the defense. probation.
That would be my, just.
Okay.
I'm just doing this because I noticed that on Wednesday, when I talked to my client, he's telling me some information. I just have to come right away and talk to the beautiful.
But wait a
probation officer.
Okay, all right, but
And
wait a
the
minute.
Information I was correct.
State, you're saying that he entered illegally before he was placed on probation?
Correct, Your Honor. And the supplemental report.
Because that's,
When I review the supplemental report, it states specifically what my client was saying to me. So that's what I came fast outlining yesterday. Try to.
well, am I reading something incorrectly? Because it says that he was placed on deferred adjudication on June 3rd, 2022.
Correct, Your Honor. The defendant was arrested for the illegal entry charge on February 5th of 22. And then was charged with the illegal reentry on 6/7.
Yeah, just they knew that he was already with the illegal reentry charge, federal charge.
Mhm.
And as soon as this court granted him the deferred adjudication on the 3rd, right next day on the 4th, immigration took custody of him and charged him with the February 2nd reentry previous to the actual deal, and put him in an 18 months imprisonment sentence.
Okay, but why do we have on or about June 7th, 2022, and the motion to revoke as the new number one?
Because there is, I believe, Judge, that in supplemental report, some immigration officer contact or the probation official and told him that he was gonna be charged for the illegal reentry, and after that they just filed the illegal reentry, maybe thinking that it was a new one, but it's actually predated the actual deferred.
So let me see if I have the time right. He was placed on deferred adjudication on June 3rd, 2022.
Correct.
And immediately he was taken into custody
Correct.
and kept there for 18 months.
Correct.
And then they came back after that and charged him with this. So then the on violation of condition number 1 should not be in the motion.
Correct, Judge.
So you don't have anything for the court to hear.
Correct, Judge.
If the violation
Predate.
of condition number 1 predates when he was placed on probation, I can't punish him for something that he did prior to being placed on probation. So it's a motion that should be withdrawn because you don't have any allegations for the court to consider.
That was my first take at it, Judge.
I can have one moment to reach out to my partner.
Sure.
Maybe this was to have hesitate, agitated, so,
Okay.
but I was trying to get into that point.
I mean, all I can do is admonish him, and I believe they will pick him up from the jail.
Judge, and I have this partner here, workman carpenter for 22 years. We even work with 30 homes, have a vendor number of 30 homes, have 4 kids, all US citizens, 7 to 18. It's a hardworking man, Judge. Just need time to do his deferred and work. That's
Okay.
it.
But I don't know. That's a federal matter, whether they pick him up or not, but I don't have jurisdiction over anything if the allegation that's in the motion predates when he was placed on probation. And that's all that's in the motion. So
I think it was
the
just
motion would have to be withdrawn.
The VA just received, they received, the probation official just received a call from the immigration officer later, after the deferred. So maybe that wasn't the mistake at all, you know?
Okay,
So, yeah.
all right.
And I know how ADA works. It's a bunch of stuff that they have to deal with it. So.
Okay. Thank you very much.
Thank you, Your Honor.
All right, are we ready, counsel? Are we ready on your client? All right, because we're bringing the jury in. Hi, and the interpreter is here. Yes. Okay. Yeah.
So that's why.
Yes. But now they're telling me that that's incorrect. The date is incorrect. That's what the state is telling me. Can you check and see if the jury's here?
I already checked your.
Okay.
Right, did I answer you? No, this would be a part two.
Yes, and but we know, don't let her stay. That's the takeaway. But you know what? None of that would have happened if they would have had the helpful judge.
Norma's out today?
Oh, no, she's going to be late. She has a doctor's appointment. Diana, I searched all the rooms till I found you.
Oh, I'm sorry.
Oh, no. No. I don't want you to tell me which room you're in. It's fun trying to figure out which room you're in.
You can't.
No, I like that. Mhm. Yes, so on Cano,
Yes, sir. So based on the dates of the actual arrest and the charging on the violation, the state is going to be withdrawing that.
okay.
Thank you, Judge. Appreciate your time and giving me the opportunity to bring this man today.
All right, thank you.
Thank you very much.
Have a good day.
All right, and counsel, Mr. Pastrano, if you'll let your client know, because I know you speak Spanish, he is not allowed to come back to the United States. Oh, if I could have Mr. Cano come up, please.
Thank you, Judge.
Sure. Hello.
Good morning, Your Honor.
Good morning. You're a new interpreter. What's your name?
A new thanks to Miss Carol, but no, I'm not new. Vicky Cavazos Jones.
All right, nice meeting you.
That was, thank you.
All right, Mr. Cano. The state has informed me and the defense have informed me that they're withdrawing the motion to revoke. I'm not the person who placed you on probation. It was another judge. I can tell by the legible writing that it was not me who wrote this. You are not a citizen. You are not allowed to be in the United States unless you are here legally. Do you understand?
Yes, Your
All
Honor.
right. I understand that you have a family here. I understand that you work here. I understand that you've been paying taxes here, but you have to be in the country legally. So the state withdrew the motion because they are saying that the allegation in the motion predates the motion to revoke. So it would be unfair and illegal for me to hear a motion to revoke alleging that you committed an offense prior to being placed on probation. Do you understand?
Sí, su señoría.
Yes, Your Honor.
So you're not allowed to come back to the United States unless you are here legally. If you are here illegally, that is going to be a crime, and that's going to result in a motion to revoke being filed. And with that motion to revoke being filed, if the court were to find it true, the court could sentence you up to 10 years in the prison. And then what would end up happening is you may end up being sentenced to prison. And then when you're released from prison, you'll be sent back to your country of origin. Do you understand?
Sí, su señoría.
Yes, Your Honor.
So if you wish to be in the United States, you will have to do it legally. Do you understand?
Sí, su señoría.
Yes, Your
All
Honor.
right. Do you have any questions about anything?
¿Cuál es el proceso a seguir?
What would be the next step in the process?
Oh, what is going to happen is they're withdrawing the motion. So this case will not be holding you here, but the federal government may be picking you up to deport you. But that is not within my jurisdiction or my purview. Do you understand?
Sí, su señoría.
Yes, Your Honor.
Now, if for some reason the federal government does not pick you up and deport you, you will still need to report to probation. If you do not report to probation, then a motion to revoke may be filed. If you are deported, it would probably be best for you to pick up the phone and call probation and let them know you have been deported. Do you have any questions?
Sí, su señoría.
Yes, Your Honor.
What are your questions?
Entonces todavía tengo una, ¿cómo se dice? Una aprobación. Todavía estoy en aprobatoria.
So then I still am on, and how do you say this? I'm still on probation.
Yes.
Sí, está con autorización de libertad o libertad condicional.
The previous judge gave you deferred adjudication for 4 years. And counsel, 4 years. And counsel, are you appointed?
No.
You were saying? Okay. The reason why I asked that, counsel, is because if you're appointed, there's an immigration attorney right behind us. And I'm sure if needed, because I don't know if you do immigration or not, she can probably explain to him potentially what may happen. All right. So if you could help and let him know what the process is. The motion to revoke has been withdrawn because the illegal reentry predates the date of the motion. I'm sorry, predates the date he was placed on probation. So he's not here legally. So he's wondering what will happen once this is withdrawn. And I don't know the entire federal system as it relates to that. I always tell people immigration is a specialty of its own. It's like bankruptcy law. Don't get involved in that. Don't get involved in immigration unless that's your practice. Okay.
Thank you, Judge.
All right. You're welcome.
Thank you very much.
So she'll be able to help you or at least give you some information. Aguilar? Yes. Okay. All right. Are you all ready to proceed?
We are, Judge.
Okay. Yes.
Mr. Aguilar?
All right. Do we need an interpreter?
No, Judge. You speak English.
Okay.
Judge,
Court-
sorry, just right before we start, this is Michaela, this is our intern, and she got her student bar card, so I was just gonna have her stand with me. if
Oh,
that's all right.
great. Hello, Michaela. We're gonna have to get her name on the record.
Yeah, absolutely.
Okay. I was a student attorney once, and it was all very terrifying. But then you get your name on the record, it's fabulous. But then once you're no longer a student attorney, you're just, oh my gosh, my name is on this by myself and no one else. All right, the court is going to call 2023 CR 4007A, State of Texas versus Mario Aguilar. Can I have parties announced for the record for the state,
Hank Wilkins and Michaela Mandola for the state.
for the defense?
Robert Gear for defendant Mario Aguilar, judge, and I'm assisted by Sarah May.
All right. And so I know that we were completing this plea, and then there was an issue about his immigration status. So I'm just going to start everything over from the beginning as though we never did anything before, because I know now we have the immigration attorney present. Are you Mario Aguilar?
Yes, Your Honor.
Counsel, have you received all the discovery in this case, and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. And just one moment. I'm sorry. Could you give me that one? Stop. Mr. Aguilar, I'm going to show you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
All right. And my understanding, there's been a change in the plea agreement. Is that correct?
That is correct, Judge.
All right. So you're also applying for deferred adjudication. Is that correct?
That is correct, Your Honor.
All right. Counsel, if you have time, if you could get a document that says deferred adjudication.
This time or after the plea? Judge?
Yes, if you could get it now. All right, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, we do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Aguilar, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
I'll let you.
Yeah. Oh, yeah. This is your application.
Are they all here? Okay.
4007.
My approach, Judge.
Yes. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe that he was and he is, Your Honor.
Mr. Aguilar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Resident.
All right. Have you had a chance to confer with an immigration attorney?
Yes, Your Honor.
And has that immigration attorney informed you of the impact of entering into a plea in this case
Yes, Your
as it
Honor.
relates to your status?
Yes, Your Honor.
All right. Counsel?
There is a Padilla on file.
All right. And what will be the consequences of his entering a plea?
It is a deportable offense.
All right. So do you understand by entering a plea into this cause number that the possible consequences are deportation, exclusion from admission into the United States, and denial of naturalization?
Yes, Your Honor.
Knowing that, do you still wish to continue with this plea?
Yes, Your Honor.
And has your immigration attorney informed you that this is a deportable offense?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $500 fine. State recommends deferred adjudication. There's to be the theft course and MRT course. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not been any such motions, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 8 years. There be a TAP evaluation, 100 hours of community service restitution, and no contact with Charles Williams. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
Your Honor, I submit States Exhibit 1 in the attachments.
Any objections?
Defense is reviewed, Judge. We have no objections.
All right, Mr. Aguilar, you and I have been communicating in English. All of these documents are in English. Have you been able to understand all of the documents in English?
Yes, Your Honor.
And do you need an interpreter?
No, Your Honor.
Going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, if we can go off the record for a moment. All right, state. Are you offering into evidence a supplemental?
Yes, Judge, at this, I'd like to supplement States Exhibit 1 with that new attachment, Judge.
Any objections?
Defense has no objections, Your Honor.
So. Court is calling 2021 CR 4470, State of Texas versus Richard Anthony Thomas. Parties announced for the record for the state.
Ruben Herrera and Travis Banks for the state.
Defense.
Dr. Bias on behalf of Richard Thomas, Your Honor.
Are both parties ready to proceed?
State is ready.
Defense?
Defense is ready, Your Honor.
All right, let's bring the
Mic stitch.
All right, thank you.
Sorry.
All right, everyone, please be seated. Defense, you may call your next witness.
Yes, Your Honor, the defense calls Richard Thomas.
All right, can you raise your right hand?
Yes.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you keep your voice up so that the members of the jury can hear you and the court reporter can hear you. All right, if you state your name for the record.
Richard Anthony Thomas.
All right, defense.
Thank you, Your Honor. Mr. Thomas. Could you describe for the jury your relationship, if any, with Nina Sanchez?
As of right now, or
Let's back up a little bit.
okay.
Let's talk about when this allegation started.
My relationship with her, really didn't have one. I was kind of distant from her and Jacqueline.
Tell you what, let me ask you this. Were you strict on them?
Oh, yes, yeah.
Why?
For one, that's the kind of parent that I am. But for two, I think I didn't want a relationship with them. I had left I separated from my wife, and I left my daughters and my son behind. And I think I kind of took it out on them.
So you're not surprised that Nina hates you?
Yeah, no, not at all.
I'm gonna switch it a little bit because I'm gonna get to the point. Did you do what Nina said that you did?
No, sir.
Did you touch her inappropriately?
No, sir.
Did you have a sexual relationship with her? Did you steal her virginity from her?
No, sir.
In fact, tell the members of the jury, how is it that you came about on giving this infamous confession?
I remember that they removed my children from the house. I believe I came home, my wife told me, or my wife called me. And I believe they spoke to my wife first,
the CPS, and then they said if I would,
Objection, hearsay.
Overrule.
they said if I was willing to go in and give my statement. So I didn't have a problem with that. So I went in and talked to Miss Belinda. Right off the bat, she was very rude. She treated me like I was already guilty. I explained my side of the story. I told her none of that never happened. And obviously she didn't believe me.
And so to prove your truthfulness, you submitted to a polygraph test, is that correct?
Yeah, she recommended a polygraph test, and
Explain to the jury how that polygraph came about. What happened in there?
I know they asked me, I don't remember the questions, it was very long ago, but
Did they ask you to lie?
I believe so.
And so you had to lie.
I think, yeah,
And then they asked you whether you have lied in the interview,
correct.
and you told them,
No,
and so that's a lie.
correct.
That's the polygraph base of supposedly telling you that you failed this polygraph.
Yeah.
Were you truthful in this polygraph?
Yes, 100%.
And did you tell him at any time that you touched her, Nina, in any way?
No,
Well, then Mr. Martinez comes back and says, you failed the polygraph test.
correct.
May I approach you on?
Yes.
Now, we have what the state has introduced into evidence, the only piece of evidence introduced in this case. And voila, a polygraph test leads you to write that or sign that.
I signed it.
So you didn't say, hey, by the way, this is what I did. They told you what you did
Correct.
and you signed it.
Yes.
Please look at the members of the jury because they're deciding your fate. Why in the world would you do that?
Well, first of all, I was told that I failed the lie detector test, which I found out that wasn't correct. So I felt in order for me to get my children back, if nothing I said, that they would believe me.
So you signed that document
Correct.
under duress.
Yes, sir.
Now, Brojan,
Yes.
I noticed something very interesting in that document. Because when you submit a statement, all it requires is your signature, correct?
Correct.
Whose signature is right below yours?
Belinda.
Why would her signature need to be there?
Objection, speculation.
Sustained.
And then what would you have to have a witness?
Objection, speculation.
Sustained.
I tell you what. Was that statement what Nina recanted later on?
Yes, sir.
And so, which is why you were not charged.
Correct. They dropped the charges in court.
So we know that she recanted something,
Yes,
and that's what they had against you.
correct.
May I approach, Your Honor?
Yes.
Here we are. Tell the members of the jury. When was this statement taken?
In March 1st, 2007.
2007. How many years is that? Let's do this together. 2008, 2009, 10, 11, 12, 13, 14, 15, 16, 17, wait, 18, 19, 20, 21, 22, 23. How many years is that?
23.
No.
Oh, I'm sorry.
By the way,
16 years, I'm sorry.
do you graduate from high school?
No, I didn't.
Do you have a GED?
No, I don't.
Did you feel powerless in front of all these people? The detective,
Most definitely.
Belinda,
Well, yeah, because I've never been CPS. I'm
you have no education, correct?
correct.
You never had any occurrences with the law before.
No.
This is just the only time,
Correct.
and you felt trapped, didn't you?
Most definitely.
16 years. Here we are. Why are you wanting to tell your side of the story to the jury?
Because I believe that there's a there's more to it,
Objection, Your Honor, to what the defendant believes.
Overruled.
because there's a lot more to the story than just this confession
Nina tells stories, doesn't she?
all the time.
And most of them are pretty credible.
Objection, improper impeachment.
That'll be overruled.
Yes, she does, many times, and I'm not the only one that she's ever said that touched her or.
Now I want you to again look at the members of the jury and tell them, did you touch Nina in any way inappropriately?
No, I didn't.
Did you have sex with Nina any time?
No, I didn't.
Did you break her virginity to the point that she was bleeding in the sheets
No,
in your room? Did you ejaculate in that bed right next to her?
no,
Have you ever walked naked to grab her?
no,
Have you ever walked naked in front of your children
no.
with her? Apologies. Mr. Thomas, why are we here?
Because every time that I gave my side of the story, nobody ever believed me.
Here we are yet one more time. And may I approach your honor?
Yes.
What the jury is gonna have in front of them is this. Why would you do that? Why would you confess to something that you didn't do?
Because when I told the truth, it didn't get me nowhere.
So now you lie and then your children are returned to you.
Correct.
Was that a relief?
How big we?
Let me ask you a question. In hindsight, would you have done it again if the state would have taken your kids?
Oh, yes. I mean,
Why? I mean, here you are facing a jury of 12 people.
because at that time, I wanted my children back. And I didn't know what was gonna happen next.
But if you didn't do it, why in the world would you say you did it?
Because every time that I told Belinda or I told anybody, it seemed like it didn't get me nowhere.
The investigator, did he ask you to collect sheets of this blood supposedly that was all over the place?
No,
Has anybody other than the polygraph asked you to submit to some kind of treatment?
no,
Mr. Thomas, 2007, you make a pseudo confession to get your kids back, and we're here. How does that make you feel?
Objection, relevance.
Overruled.
uh-huh. It's hard. Because I don't know. I don't know what would happen, what's gonna happen next. And it seems like every time I told my side, or I never shied away from CPS, I never shied away from the detective, always went in and gave my side, and time after time, I they didn't get me nowhere.
You were the suspect from the very beginning, weren't you?
Yes,
And you were their target.
yes,
To this day, you're still their target.
correct.
Because now they're gonna show the jury that you confess.
Right.
You lied in that confession, didn't you?
Yes,
In fact, that's not even your confession, that's Belinda's confession. Is that correct?
correct,
You just signed your name because you wanted your kids back.
correct. What was told by the one who conducted the lie detector test, if I wanted my children back, that I have to be remorseful. I have to call Belinda and let her know that I want to confess. And-
Even though you did not do it.
And he told me that I had to be.
Sustained.
Now, this is your chance, Mr. Thomas, to tell people that will bring finality to this case. These 12 individuals right here. I want you to look at them in their face, in their eyes, and tell them your side of the story.
I never touched Nina. I can understand why she hates me. I didn't treat her or Jacqueline the way a stepfather should have. I did fail them in that part. Looking back at it now, I wish I could have. I wish I could have treated them better. But I was going through my own thing at that time. And it doesn't make it right. But with me and Jacqueline, I was able to patch that up with her. I've been in her life for 21 years. And
At this point, Your Honor, we're going to object to narrative.
Overruled. You can continue.
and I wish I had that same opportunity with him. But there's a lot more to the story that why she would run away, and it wasn't just the fact that
Objecting on response to the question.
That will be overruled.
it was the fact that, yes, I was hard on her, but I would punish her for lying and stealing or doing things at school. So she got older, she wanted to do certain things that I didn't approve of, having boyfriends or girlfriends.
Objection under Rule 412, Your Honor.
Sustained.
Did you blame Nina?
Blame Nina for what?
You here in front of a jury. Did you blame Nina?
Yes and no.
Explain that to them, because again,
I don't blame her because of how I treated her and her sister. But the thing is with Nina, she would always go overboard. And a lot of the things she would do.
let me make sure I get this straight, because the jury is listening. How you treated Nina, did that include sexually touching her?
No,
What do you mean by how you treated Nina?
just the way I was always on her. And every little thing that she did, I would punish her.
Is that why she hates you?
I'm not pretty sure, yeah.
So I'm gonna ask you again, do you blame her?
No.
But the other side of that question is, was she truthful when she told the jury that you did whatever you did to her sexually?
Oh, no.
How can you ensure this jury that that's not what happened?
For many, many reasons. I was never alone with Nina. You know, that's just something I would do.
Mr. Thomas, this is your chance to tell to the jury whether in fact you did what they say you did.
No, I didn't.
Again, how can you tell the jury?
Objection as an answer.
Overruled.
Because I never touched her. I never, also There was never no evidence. I mean,
May I approach, Your Honor?
Yes.
I'm giving you the chance to convince the jury, but this is gonna go back there with,
Sidebar, Your Honor.
Sustained.
that. It says here that you touched her. Now tell them how you didn't touch her.
well, I never touched her at all in any way and on this time and on any other time.
But that's your signature.
Correct. But like I said,
Objection, no question pending.
Overruled.
the reason why I did sign that was to get my children back.
I have no further questions from this witness, Your Honor.
State.
Mr. Thomas, you're telling that this jury today that you lied to CPS.
Correct.
You're telling this jury that you lied to the polygraph examiner.
Know that I told the truth.
That you told the truth to the
Yeah,
polygraph.
correct. That I never touched her.
You're telling this jury that you signed that confession without reading it, without knowing anything that's on it. That's a yes or no question.
What was the question again?
Are you telling this jury that you signed that without knowing what you were confessing to?
No, I signed it knowing.
Okay, so you read that document before signing it, correct?
Correct.
You saw all the allegations that it made in there, correct?
Correct.
And you still signed that document.
Correct.
And you're telling this jury that that was a lie.
Correct.
And you lied to get your children back. Is that correct?
That's part of it.
That's a yes or no question. You lied by signing that document to get your children back.
Correct.
So you lied to benefit yourself in that
To
that would
benefit,
help you get your children back.
to benefit my family, getting myself, to get my children back. Correct.
And you're telling this jury that now they should believe you even after you've already said to them that you would lie to benefit yourself. Yes or no?
Correct.
Now, you said that every time you've told your story, nobody believes you. Isn't that right?
Correct.
Isn't it possible that nobody believes you because you've already admitted to lying before?
Objection, Your Honor, argumentative.
Overruled.
That's a yes or no question.
What was the question again?
Isn't it possible that nobody's believed you because you've already lied in the past?
No, they didn't believe me because they didn't want to believe. They didn't give me a chance. CPS didn't do, did she say she did an investigation? There was no investigation at all.
Well, didn't you sign a confession saying, admitting to touching Nina?
Correct.
And you're also saying here today that you got your children back right after you signed that confession, isn't that right? It's a yes or no question, sir. I'll rephrase the question. Didn't you just tell this jury that you signed that confession and then got your children back?
Yes.
But didn't Santa tell this same jury yesterday that it was months after you signed that confession?
Objection, Your Honor. So in fact, not in evidence, may say this of the statements.
All right, so I'm gonna need you all to speak slowly so that the court reporter can write everything down. What is your objection?
So in fact, not in evidence and misstatement of the evidence.
All right, that will be overruled.
Isn't it true that Santa told this same jury that it was months after you signed the confession?
But you didn't
And
ask,
you were even back in the home?
you didn't ask if it was months. You just said if we got our children back.
My question to you now is, isn't it true that Santa told the jury that it was months after
I don't remember.
that you came back? Let me finish my question, sir, okay, please. Isn't it true that Santa told this jury that that it was months after the confession that the children got back?
I believe so. I don't remember what she said.
And this case was still pending even after the children were back in the home. Isn't that correct?
No, we got our children back. It was closed.
Wasn't this case open for? Isn't it true that this case was still open in 2008?
I don't recall.
Weren't you arrested on this case in May of 2008?
Yes, that was the case that was dropped.
So you wouldn't have had contact with the children until after that case was closed.
Correct.
So you didn't get the children back right away. You didn't even have contact with the children until after the case.
I had contact with my son and my daughter.
But then you didn't get Nina returned, did you?
Her mother did. Her mother got Nina and Jack.
Mr. Thomas, if you know, who took the children from your home?
I don't know.
Would it surprise you to know that Santa, after being notified of your confession, took the children with her to her mother's house?
Sounds about right.
So nobody ever took the children from you. Santa took the children, isn't that correct?
No. That's
Isn't that what you just said?
No, I said they removed the kids. After the confession, we were able to get the children back.
You keep saying they removed the kids. Who removed the kids?
I believe it was CPS.
But you just said you didn't know.
I mean, I did know, but I didn't know who exactly. But I knew CPS had taken away the kids.
So then, when Ms. Castellanos testified to the jury that she has no power to remove the children from the home, she's lying?
Well, I don't know. I don't know her position on removing the kids or not. But I know my kids were removed from the house.
So when she's saying that the children would not have been removed at the time of the investigation, that's a lie.
But what was the question again?
When Melinda Castellanos testified and said that the children would not have been removed at the time of her investigation, that's a lie.
That is a lie, because the kids were removed from the house.
So basically, everybody else is lying except for you in this case.
Objection, Your Honor, argumentative.
Sustained.
Nothing further, Your Honor.
You know, perhaps you don't understand the term removed. The prosecutor is stating whether the state filed some kind of paperwork and then they were removed legally. But your children were taken from the house, is that correct?
Correct.
Is that what you mean by removed?
Yes.
So their children were not able to sleep in their beds at night for a while.
Correct.
Now, the prosecutor wanted you to show that, you know, Santa says
Objection,
months.
sidebar, Your Honor.
Sustained.
Isn't it true that Santa said 1 month?
I believe so.
I mean, you're under investigation. Are you stressed?
I'm very stressed.
Are you thinking whether it's a month, a day?
Not at all.
Your children were taken away and now they're brought back.
Correct.
When did that happen, sir?
When the children were removed,
Brought back.
to be honest, I don't remember.
Why would Santa have to take her children away from her house?
And that's what we don't understand.
And that's what you're referring to remove, right?
Correct.
Now, pros, Your Honor,
Yes.
it was only after she typed this and you signed, is that correct?
Correct.
Now, your children are gone.
Yes.
Now, actually, they're gone. Now you submit this,
Yes.
and then a while back, they're brought back.
Correct.
But you just stated in 2008, you got arrested, correct?
Correct.
That's subsequent to that.
Yes.
Is that when Nina recanted her story?
Yes.
Why in the world are we here again?
I have no idea.
Nothing further from this witness, Your Honor.
So at the time that the children were removed from your home, where were they?
I believe they went with Santa's mom, I believe.
So they weren't in the foster home, is that correct?
No. Yeah, they were.
So nobody from the state removed them.
All I know that they were removed from the house.
Where was Santa at the time?
I don't remember.
Was she able to see kids?
I believe so.
So she still had custody of the kids at the time. They just weren't living at the home.
Correct.
Nothing further, Your Honor.
Nothing further, Judge.
All right, you may step down. Defense, call your next witness.
At this time, the defense rests.
All right, state,
State rest and close, Your Honor.
defense, do you close?
Defense closed, Your Honor.
All right, ladies and gentlemen, I'm going to give you a break until 11 because there are some other things that we need to take up outside your presence. It's not involving this case. Remember the court's instructions that you're not to start deliberating internally with yourself or with each other. Everything that you need to know about this case is to come from inside this courtroom. Does everyone understand? All right, everyone, please rise for the jurors. Going to print out the proposed jury charge.
Can I request that I get 2 copies so I can,
Oh, most definitely.
thank you, Your Honor.
Let me see. Is there anything specific that someone wants in the charge?
Just the honor about language, Your Honor, that's explained in the jury charge.
Your Honor, and if possible, if possible, an indication in relation to polygraph and the admission or inadmissibility of polygraph examinations. I think that's relevant because that statement indicates that he submitted himself to a polygraph.
Your Honor, the state would object to that as the door. I'm sorry, Your Honor.
All right, so here's the thing. You all can discuss it amongst yourself with regards to the polygraph. My understanding that there was a hearing that was held suppressing the polygraph,
That is correct.
but then people entered statements with the polygraph in it, and people let witnesses testify to whether or not they took a polygraph test.
That's what I believe is imperative, that we have a paragraph explaining to the jurors the law on polygraph, Your Honor.
I understand what you're requesting, but the court's question is, why would you all have a hearing on whether or not the fact that someone took a polygraph is admissible or not? Then that previous judge, which I believe was Judge Angelini, ruled it was not admissible. And then everybody is entering documents with no objection to the fact that a polygraph was taken.
Again, Your Honor, you're correct. Judge Angelini ruled against the admissibility of the polygraph. However, that was contingent on the indictment. It was an attack on the indictment. Therefore, we should have been here. But he continued us to go to trial, even though this confession was obtained because of a polygraph. That was the gist of it, Your Honor. And so because of that, it's imperative that the jury hears the law on polygraph, because this confession was obtained simply because of a polygraph test, a tool that is inadmissible in court. And yet, here we are.
So it appears as though everyone went behind Judge Angelini's ruling.
Your Honor, the state would ask that.
Oh, we're just,
Judge,
you all, here's the thing. Mr. Bias, you all can formulate your arguments, state, you can formulate your arguments, then the court will hear it.
Okay. We're
We're going to take a brief recess for us. The jury's going to be back at 11, but we'll be back at 10. 45. Okay,
Thank you, Your Honor.
you're welcome. You can mute us. All right. Defense. With regards to the jury charge, my understanding you wanted the presumption paragraph moved, so that will be moved, and you wanted it placed with the other paragraphs that state our law. So that's going to be changed.
As the court is aware, the court is the only entity that gives the law, and I don't see any paragraph that says our law provides.
All right.
all
All right,
persons
I'm
are-
granting your motion on that.
Okay, thank you.
So now, with regards to the other issue, what is the other issue, counsel?
Is I believe that because the introduction of 2A, even though there was against the previous rulings, and again, the introduction was submitted by the state polygraph test, that I believe that the jury should hear the law on polygraph examination, and this is based on Tanner v. State 802 Southwest 2nd 678 633 Texas Criminal Court of Appeals in
You need to slow
1990.
down so that the court reporter can take it down.
I'm sorry.
So Tanner v. State, and what is the
80
side?
802 Southwest 2nd 678, 683 Texas Criminal Appeals 1990, in which the Court of Appeals or the Court of Criminal Appeals found that the court erred in admitting that any part of the testimony of polygraph examination, such as this confession. Then Netherly, this state 692 Southwest 2nd 686 700 Texas Criminal Appeals in 1985, where the court indicated that only could be admissible if the parties agrees. The defense is quite adamant in not agreeing with this polygraph test. That's why we submitted court hearings earlier on in the proceedings. Then in Fry v. United States, this is a Supreme Court case 293 F1013, in which the general acceptance doctrine that polygraph examinations are precluded from bringing into the trial. And so because of those case law and others, Your Honor, for time experience, I believe that the jury should be entitled to hear the law on polygraph examination, because Exhibit 2A speaks of polygraph examination. And if we don't explain the law, they're gonna presume that, well, it's a polygraph, it must be admissible. And that's where the confusion can be created, Your Honor, unless the court explains the law to the jurors. And for that reason, the defense believes that an inclusion of that paragraph of the law in relation to polygraph test should be part of the jury charge. Bless you.
All right, so defense, because I'm not the one who heard the motion to suppress, I just want to make sure that I have the sequence of events correct. The motions to suppress the polygraph examination was heard with Judge Angelini, is that correct?
That is correct.
All right, and Judge Angelini,
Your Honor.
excuse me,
There's a correction.
and Judge Angelini granted that motion, is that correct?
The motion to suppress the confession because of polygraph examination.
Okay.
The Judge Angelini did not grant that. He says confession comes in.
The confession comes in.
That's correct.
But not the polygraph.
Not the polygraph, which is why I didn't bring the polygraph nor the examiner. So that's the confusion, Your Honor. And so the evidence.
Counsel, did you not ask in State's Exhibit number 2, State's Exhibit number 2, the mention of the word polygraph was redacted, correct?
That is correct.
And you asked that 2A be admitted, which would be
Unredacted.
unredacted. And that unredacted contained the fact that your client was alleged to have taken a polygraph.
And Your Honor, I believe you granted that on best evidence rule. That was my objection. You granted it and you said, okay.
Well, no. So that the record can be clear,
Mhm.
is you wanted the unredacted portion.
On the best.
I
evidence.
asked the state if they had any objections to the unredacted portion, and the state said no. So it wasn't the court ruling that
My
it should be
objection,
admitted.
my objection to the introduction was the best evidence rule. And so you went back to them, if you want to unredact it, and they say yes, and so, but I made an objection to the best evidence rule,
So you wanted the full,
everything,
you wanted the full document of 2A into evidence.
correct?
And that full document contained the fact that your client is alleged to have taken a polygraph. Is that correct?
That is correct, Your Honor.
And the state had redacted out in state's exhibit number 2 that a polygraph was taken, correct?
That's correct, Your Honor.
So now your complaint is you want the jury to know that a polygraph is not admissible.
I don't have a complaint, Your Honor. I believe that is in the pursuit of justice and fairness, the jury should be entitled to hear the law on polygraph examination. I'm not asking to tell them not to believe the document. They should hear the law on polygraph examination. That's it, Your Honor, because of the unredacted part of that confession.
All right. So that objection will be denied. Is there anything else from either side?
Nothing from the state, Your Honor.
All right.
So for the defense, Your Honor.
All right. So what we'll do is you each will have 15 minutes. I'm going to get the jury charge. And then I will give you all copies.
Thank you, Judge.
And does anyone want a time announcement?
If we can have a time announcement with 10 minutes left, Your Honor.
Okay. And who's doing the closing, both?
Yes.
And do you want a time announcement?
Just me, myself, and I, Your Honor.
No, I mean, do you want a time announcement?
2 minutes left.
Okay,
Thank you, Your Honor.
And Judge, for mine, can you let me know after 2 minutes has passed?
okay,
And just open a trap door or something.
okay. All right. So,
Yeah.
all right, then they will have that. So if y'all remain, they will give you the information. All right, Deputy Laura, we're going to start our Q&A until noon. So the Zoom link for me to answer anybody's questions on matters unrelated before the court is 864-0133-629, 864-0133-62. Oh, I said 6289, didn't I?
Yes.
I'm sorry, it's 864-0133-6298, 864-01